This is case number 5495. This is Resurgent Receivables LLC versus Kenneth Williams. Your appearance for Resurgent at this time, please.
Good morning, Your Honor. Gavin Gray, P79819 for Resurgent Receivables LLC.
All right, thank you, Counsel, and good morning to you, sir. Do I have Kenneth Williams or someone representing Mr. Williams on the Zoom? If you're here, say something at this time. Looking for Kenneth Williams. All right, I did receive the defendant's answer regarding this matter, so the matter has been joined before this court. The record should reflect further that a notice was sent out on the 31st of May, setting this date for a hearing set up as a status conference. Counsel, do you have any information regarding Mr. Williams? Have you spoken with him in the interim, sir?
No, not at all, Your Honor. I'm not aware of an answer either. I did not check the ROA.
All right, yeah, that's and you know, that frequently happens. I do see it indicates a certificate of service at the bottom, but it didn't check any of the boxes that you know, the certificate of service on the standard form. It gives an option to say they were personally served or served by first-class mail. It doesn't check either one of those, but it indicates that it was served on the 24th of May of 2022. So this is not altogether uncommon. In looking at the answer, it is basically a general denial of the allegations raised in the complaint. Again, we sent out the notice to the defendant notifying him that he had to be here on today's date, or that other action or relief could be taken in this regard. So your pleasure at this time, Counsel, given that this was set for 9:30, it's now 5 minutes after 10. Counsel.
Your Honor, I think what we'll do is we'll just send in the default entry request. I think is what we do here in the 36. Is that correct?
Yes. So you're moving for a default at this time. Is that correct?
Yes, Your Honor. I'd like to include a filing fee of $55 and a service fee of $53.40 as well.
All right. Thank you, Counsel. Granted, the court will enter the default at this time and will enter the judgment upon receipt. Basically, I allowed for a 14-day lapse. The default is entered by court order today, and then after the expiration of 14 days, the court will enter the judgment on that default. You can submit the order right away, and we will process it accordingly. In fact, you can send it by way of email if you wish to do that. I'll give you an email address if you want to do it that way, sir. Ready?
Okay, thank you, Your Honor.
All right, that's Latifah, LATIFAH .Hunter at 3636GH 36districtcourt.org.
Okay, got it.
Thank you, Counsel. We'll await that order, sir.
Okay, thank you. I do have one more case with here, and it looks like the defendant is here. Would it be okay to be placed in a breakout room with them at this time?
Sure. Who do you have? Who's on the other side of that?
Edward Newsom.
Where's Mr. Newsom? Mr. Newsom, Edward?
Yes, Mr. Newsom is here.
All right, Mr. Newsom, the attorney is asking to have an opportunity to speak with you. So I'm going to send you a notification right now to go to breakout room number 1. And the attorney is going to meet you there, and you have a chance to talk about this case, and then you'll be able to come back in. There's your notification. All right, this is case number 21151422. This is Enhanced Center Interventional Spine versus Allstate Insurance Company. The matter is before the court for a review. Your appearance for Enhance at this time, please.
Good morning, Your Honor. Richard Brewer, P31124 on behalf of plaintiffs.
All right, thank you, Mr. Brewer, and good morning to you, sir. For Allstate Insurance, your appearance at this time, please.
Good morning, Your Honor. Brandy Anderson, P 70876, appearing on behalf of Allstate.
All right, thank you, Ms. Anderson, and good morning to you, ma'am. Good to see you. All right, so in my notes here, I see that, well, this was evaluated some time ago, but it was adjourned so that some other activities can occur. Somebody update me, tell me what's going on.
Yeah, Your Honor, in May, we case evalved, neither side accepted. We've been here now, I think, twice or three times for reviews subsequent to that. I'm just waiting for an offer. I've never received an offer.
Yes, Your Honor, that is correct. I have sent over the demand and the bill to my adjuster. He is still evaluating this claim. I know we've been here a couple of times. So, but at this point, I still have no authority. You'll probably want to just set it for a trial date. Now I was, asked that you set it out as far as you can.
Anything, Mr. Brewer?
No, Your Honor, one way or the other, we got to get it resolved. And if a trial's it's gonna take a trial, I'm okay with that too.
Yeah, maybe that's the right thing. I take it that there is a jury demand in this file, correct?
Correct, Your Honor.
Yes.
All right, so we'll set it on for trial by jury. And I'm looking to a date right now.
The jury, next date, October. We have to pick the days, remember?
I know.
I don't know what days they gave us. They didn't give me October dates. Do you have any October dates for the jury trial?
Just
that it.
work it in there.
Okay.
Yeah.
October. 9th.
Administratively, they've got me on a leash in setting these juries. Some crazy
You
limitations.
can
I
try
had to push it anyway and set that day before.
You can try the 19th.
10/19, 22.
Your Honor, I am actually on vacation that day.
Well, you're gonna have to change that. Have you got 8 weeks notice? Let's see what we can do here.
Let's try the 25th.
Oh, wow, that's all. Okay. 10/25. Are you back in, council?
I am, and I can do that.
All right. Madam Council?
Yes, Your Honor.
All right, we'll set that. All right, we're gonna set that for 10 o'clock a.m. I have to start that kind of late that. All right, 10 o'clock a.m. 10/25/22. All right. I wish you well. I know you're trying to move this forward. Hopefully it gets worked out. Otherwise, we've got something set up here.
Thank you, Your Honor.
Thank you, Your Honor. Have a good morning.
Likewise, sir. This is case number 22181636. This is One Detroit Credit Union versus Shanicia the Piers baby. If I'm saying that wrong, we'll get it corrected. The matter is before the court, set on for a hearing on today's date. The court is in receipt of defendant's answer to the complaint in this matter. That answer, the date of that answer is 5/27/22. It is timestamped on that date as well. The court did send out a notice on June the 1st, indicating that this date would be the date for hearing in this matter. Your appearance for One Detroit Credit Union.
Good morning, Your Honor. Wesley Neal on behalf of One Detroit Credit Union, P number 80307.
Thank you, counsel. I'm looking for Bailey. Last name is Bailey, lives in Santa Barbara. If you're on the Zoom, say something at this time.
Yeah, I'm here.
All right, what is your name?
Shantasia Bailey.
Oh, all right. I really messed that one up. Thank you, Miss Bailey, Shantasia. That's a beautiful name. All right. I received your answer. Counsel, did you receive the answer regarding this matter, sir?
We did receive the answer, Your Honor.
All right. Have you had a chance to talk about this at all, to see whether or not there is a possibility of getting this resolved? I don't have a complete file this morning, but I note that the claim in this matter, I do have a register of action. The claim in this matter is in the nature of approximately $4,800. you think talking about it for a moment, might, be able to, the parties might be able to find some way to resolve this?
I'm always open to having communication, Your Honor. Since the defendant and I have not spoken directly, I would love that time. If the court would allow us to go into a breakout room, that would be great. If the court does have other matters it needs to move on to, I would just ask for a scheduling order and we can make contact between the parties.
Let's take a moment now, Ms. Bailey. I'm going to send you a notification to go to a breakout room to talk about the broad parameters of what resolving this might look like. And then you'll need to click back into the courtroom one way or the other. And hopefully there's a way to resolve it. If not, then the court will put it in the process of discovery and other items that are associated therewith. If there's something to be done to resolve it, this gives that opportunity to do that. So I'm clicking in now. There's your notification, Ms. Bailey, and I'll talk to you and Mr. Neal on the other side. Thank you. All right, who do I have there with the suffix 2463?
Hello,
Yes, who are you?
my name is Kenneth Williams.
All right, why are you here? What case are you on?
I got case number 360-336-0000.
5495. He was on the searching case, the first one.
Oh, that case is in default. You were not here on time.
Oh, yeah, I got it on there.
Yeah. Yeah, that case is in default because you were, what's your name again?
Kenneth Williams.
Yeah, why weren't you here at 9:30?
I had trouble getting back in town. I'm a truck driver, and I had trouble getting back in town. And I don't mean to give you no excuses. But
Yeah, you need to be on the record at 9:30. I called that case at 10:05, and a default was entered against you at that time because you were not here. So you would have to. I know the case is for $802 plus court costs. You'd have to file a motion on the second floor explaining why you were not here and asking to set that default aside. I know that this is a case about a credit one account. So what happened
yeah.
here? Did you buy something on it?
I ended up getting sick and end up falling back on my bills. But I think these guys had took my tax return, and I hope that'll be partial of payment.
Well, on this one, they couldn't have had taken your tax return. It must be another bill because they didn't have a judgment or anything on this one.
Oh, okay. Yes, sir.
But they've offered a judgment to be entered. You know, you can always ask for partial payments or anything like that. You could file if you believe that that's what the issue is, that you would need time to pay it or something like that. You could always file for partial payments. And then
Okay.
a certain amount that you would pay every month, because your
Sounds
judgment
fine.
it's not a huge amount, although, I know it's $800 or $900, but you could get a partial payment order. You'd have to file something on the second floor and ask to make partial payments, and that may be how you want to resolve this, okay?
Okay, I do just that. Thank you very much, and good morning.
And good morning to you. Have a good day.
Yes, sir. Thank you.
We're now back in the main courtroom. So I guess y'all gonna discuss what y'all just came up with.
You're not on mute there, so go ahead and mute yourself for now, ma'am.
Go on mute.
Yeah, go mute yourself, so, because somebody's talking and you may not want to hear, what you're talking about, so. Okay, all right, I see everybody's back now. All right, so I have Miss Bailey back, is that correct? Ms. Bailey? All right, Counsel, you're back on the One Detroit matter, correct, sir? Are you able to hear me, sir?
Are you referring to me, Your Honor?
Yes, sir, you're on the One Detroit.
Oh, Newsome, Edward Newsome.
Uh-oh, that's what the problem is. Let me go to that file, that may make more sense, all right. You're here on LNB Funding LLC. This is case number 22-184-806. And let's do it the right way. Your appearance at this time, counsel.
Gavin Gray, P79819 for the plaintiff, LVNV Funding.
All right, say your name again. We broke up a little bit.
Gavin Gray, P79819.
All right, thank you, counsel, and good morning again to you. And Mr. Newsome, I believe that you're on this Zoom. Say something to
Just
me, sir.
listening.
Yes, I'm right here.
All right, thank you, Mr. Newsome, and good morning to you, sir. Mr. Gray, why don't you update me on things? I know you wanted to break out room and talk for a moment. Go ahead, sir.
Yeah, so we were able to come to an agreement on a consent judgment. We're going to do a consent judgment for the full balance, $55 filing fee, along with a $53.
It went away, Shell.
Yeah,
Oh, I came back.
he's coming right back there.
Can you hear me now?
Yeah,
Yeah.
I hear you now. Thank you, Mr. Gray.
So we'll do a total of $1,788.83, and there'll be a payment plan of $10 a month.
All right, that makes sense to you at this time, Mr. Newsome?
Yes.
All right. All right, well, the matter is resolved. Hopefully, as time goes forward, you might be able to pay more to try to get it down faster, but I see.
Well, like I told him, I'm on disability now, and
Yes.
I don't know how the economy is going to go.
Yes, sir. Understood. All right. So I will sign that order, that document that's going to be sent to me, Mr. Newsome. And Mr. Newsome, is it all right if the attorney initial your that document for you by consent based upon what was put on the record here, sir?
Yes.
All right. And as long as it comports with those things, I'll go ahead and sign it, and then you'll get a copy of it. So that you're going to make the $10 a month until any further notice on that matter. All right,
Okay.
sir? All right. All right, Counselor, you can send that to me at the email address. I think I gave it to you earlier. You could send that judgment in with the initials of this gentleman by consent. It's already noted on the record, sir.
Yes, Your Honor. Just because it's on the record, I just wanted to make note as well that there's a mutual release stated in there that if he sticks to the $10 a month, we won't sue each other as long as he sticks to $10 a month. There's no periodic garnishments, but looks like that's not going to be an issue anyways. They do reserve the right to state tax garnishment, and I don't know if that'll actually be an issue in the scenario either.
And that's your understanding as well, Mr. Newsome. Is that correct, sir?
Yes.
All right. All right. I'll sign the order upon its presentment. And thank you, gentlemen. I'm glad you were able to get it worked out.
All right. Thank you very much, Your Honor. Appreciate it.
Today.
Yeah. Make sure you mail that paperwork to me so I can mail it back.
Well, he's going to send it to the court. I'm going to send it on to you. That's why I was asking you about him initialing it and sending it forward to me. Because as long as it says the language that you've already agreed to, I'll go ahead and sign it, and you'll get it from the court. You'll get a copy from me as well as a copy from Mr. Gray.
Okay.
All right. That makes sense to you, Mr. Newsome?
Yes.
All right. All right, sir, it's all resolved, and you'll get the signed document from me, sir. I wish you well.
Thank you.
Thank you.
All right, thank you very much, Your Honor.
Thank you, sir.
Hey, Gavin,
Yes,
how long would it take for me to get this in the mail, you think?
Probably before the week is out. If he gets it over to me, I'll get it sent out, either this week or no later than sometime next week, sir.
Okay, so, okay,
You all good there?
yes,
All right. Thank you, sir.
thank you.
thank you. Have a good day now.
Yeah.
And we're back on the record regarding the suffix 1636. That's of course 1 Detroit versus Ms. Bailey. Welcome back to both of you. Counsel, why don't you update me on things at this time, sir?
Your Honor, the defendant and I did speak. We're hopeful that a resolution will be forthcoming in the next few weeks, but at this time, we do not have one finalized. So I would just request that the court open discovery in this matter, allow us to continue with those discussions, and then hopefully have a resolution. If not, then we will probably proceed with a motion for summary disposition.
So what I'd like to do is I want to bring you back in the near term rather than in the longer term. Maybe take another look at this in the next 30 days. I certainly will allow an order of discovery. But I want to see if you could get some traction on this and maybe get it resolved. What do you think, Mr. Neal? What do you think, Mr. Neal first, sir?
That would be fine with us, Your Honor.
Ms. Bailey, anything you wanted to weigh in on that?
No, not really.
Okay. All right. So what I'm going to do is I'm going to go ahead and bring it back in 30 days. And I'm going to hold this close and I'll take a look at it at that time to see if you all have been able to resolve it. If not, then I'll get it set up and I'll put it on a pace where we can find a way to resolution in as quick a time as we can. I want to take another look at it in 30 days. All right. So that date is going to be
I'm sorry, was it 9/19?
all right, 9/19, 22, and that'll be at 9:30 a.m. 9/19/22, 9:30 a.m. All right, that will be a pre-trial date, and I'll take another look at it. And you'll get notices in the mail regarding that date, 9/19/22 at 9:30 a.m.
Perfect. Thank you, Your Honor. We have it noted.
All right, thank you, sir. Good day to you. Good day to you, ma'am.
You too.
Hi, Deborah.